Thanks, Brian. So, like Colm, I want to discuss popular sovereignty, and specifically the idea that what characterized the legal and constitutional order that developed in independent Ireland was an overarching, unifying, a definitive principle of popular sovereignty. More so than any appeal to natural rights or certainly any appeal to God, that was the legitimating principle for the enactment of the 1937 Constitution. But of course, it featured prominently in the political rhetoric of the preceding period, not only in 1916 and earlier, but also even in the 1922 Constitution itself, which is often forgotten. And of course, there's nothing unusual or distinctive about a seceding nation invoking popular sovereignty, and there's nothing distinctive about popular sovereignty being enshrined as a principle. But what I'm going to talk about is something which is arguably distinctive, maybe not unique, but distinctive in Ireland, which is the way the power of judges and the institution of judicial review has been understood with reference to popular sovereignty. Okay? You don't have to be a Marxist to understand that the concept of popular sovereignty serves mainly to obscure the real distribution of power within a state or even within a society. And so it's of limited, I think, use or value in that sense. I mean, being a Marxist would help, but you don't have to be a Marxist to accept that. So I don't really intend to take the concept or the theory of popular sovereignty at face value. I think it's better studied as a doctrine or a discourse than as a theory. But what is distinctive or what is worth investigating in Ireland is how references to popular sovereignty have been used as a legitimating principle for one particular institution in the state, the judiciary, or how judicial power and the legitimacy, the justice of judicial power has been understood and debated with reference not to natural rights or even individual rights in any sense, but popular sovereignty itself. And the relatively far-reaching powers given to judges in the independent legal order, compared to the British constitutional tradition, was not understood as a check on the popular power, as it is, say, in American discourse, or as it is largely understood in American discourse. Ireland has deviated from that path of understanding judicial power and popular power as being in tension. And what I will try to show is that judicial review of legislation in Ireland has been legitimated with reference to popular sovereignty itself. And I will argue, on the other hand, that there has been insufficient scrutiny or discussion in our constitutional culture of the effects of judicial review on our democratic culture, but where I don't want to frame democratic culture with reference to an abstract, perhaps a hollow idea of popular sovereignty. Now, first of all, I'd like to discuss briefly why the concept of popular sovereignty in the Constitution is ambiguous and perhaps incoherent historically and conceptually. Article 5 says that the nation is sovereign, or the state is sovereign, that Ireland is a sovereign state, and that refers to external sovereignty, the relation of the state to other states. And that has its own problems, its own ambiguities, its own difficulties. Article 6 refers to popular sovereignty. It states that all power derives under God, all powers of government derive under God from the people. And that refers to the internal dimension of sovereignty, the distribution of a power or authority within the state, and it designates the people as the supreme political authority in the state. Now, that conceptually and historically, it is problematic to speak of the people as a sovereign. It arguably makes little sense and arguably doesn't equate to a specific distribution of power within a state at all. Okay? we'll start in the 17th century, I suppose, with Hobbes. There are earlier references to sovereignty, of course, particularly Baudin, in the 16th century in the French context. But I suppose the main early modern theorist of sovereignty is Thomas Hobbes. And Hobbes famously understood the sovereign, I suppose, as the supreme political authority to whom the natural rights, to whom the rights of citizens, the rights of individuals are alienated, and the sovereign is decidedly distinct from the people. The sovereign rules the people, and the people authorize the sovereign through the social contract. Now, the sovereign is undivided, and the sovereign is supreme in that sense. The sovereign is a final arbiter of political authority within the state. In the 18th century, Rousseau inspires a different concept of a different understanding of sovereignty, and he locates sovereignty in the people. Now, his idea is that through the social contract, the people do not transfer authority to a sovereign, rather the people are the sovereign. Okay. And that concept is endorsed and adapted by the French revolutionaries. Okay. Sovereignty is democratized, at least ostensibly. But that already we have a tension, because the people are simultaneously the subject and the repositories of sovereignty at the same time. The people is the supreme ruler, and it rules itself. And it says relatively little about the distribution of authority within the state or how government is carried out. So it seems mysterious and contradictory, partly because we recognize that unlike, say, a monarch or an assembly, which is what Hobbes envisages as a sovereign, the people is too unwieldy an entity, too amorphous an entity, to exercise sovereignty in the sense that Hobbes envisaged. Arguably because the people, as such, is incapable of forming a will of its own volition, unmediated by other institutional forces, and therefore the idea, in Hobbes' account, the idea of popular sovereignty as we know it now simply makes no sense. Now, the assumption has been that Rousseau simply adapted Hobbes' concept of sovereignty and transferred it to the people, located it in a different repository, and that's largely why Rousseau has been understood as advocating a kind of democratic absolutism. However, Steinberger has convincingly argued that by the concept of sovereign, Rousseau and Hobbes actually refer to completely different things. In Hobbes, the sovereign is a supreme governing agent, an active governing agent, whether it be a king, a monarch, an assembly, or whatever. In Rousseau's thought, the sovereign is an authorizing agent, a constituent power, but it isn't an active governing agent in the structure of the state. So there's an instrumental idea of sovereignty and an authorizing concept of sovereignty. And a lot of our confusion around sovereignty stems from the fact that Rousseau and Hobbes use the same words to refer to something that is quite different. Okay. And that underlies what is arguably a divergence within British and French political and legal thought as to the meaning of sovereignty. The French revolutionaries locate sovereignty in the people. Very quickly, they transfer sovereignty to something called the nation. The people are not sovereign because it sounds too unstable, it sounds too threatening. So as Malberg noted, sovereignty was located in the nation, not the people, because the concern was that no constituted authority, no assembly, no institution, no discernible entity should exercise something called sovereignty at all. And sovereignty then simply seems symbolic. The powers exercised on behalf of or in the interests of or authorized on unknown terms by an entity, whether it be the nation or the people, but where that entity isn't a supreme governing agent, an active governing agent in the sense that Hobbes meant, and in the sense that is meant in English or British legal thought with reference to the Parliament as sovereign. The Parliament is sovereign in the sense of a supreme political authority, whereas in French, and arguably perhaps in American legal thought as well, the sovereign is an authorizing entity which takes no active role, or certainly no supreme role in the active governance of the state. Now, what's interesting in the Irish constitution is that it uses both concepts simultaneously. Article 6 refers to all powers of government deriving from the people, to paraphrase, and that recognises the people as the constituent power, as the entity on whose behalf power is exercised, from where it's derived formally and symbolically. But in the same article, it refers to the right of the people to decide all questions of national policy in final appeal. And so it also refers to the idea of the people not only as a constituent, but as a constituted power. And that is given expression in the understanding of the people, of the voting people in the context of the referendum, as the active, instrumental sovereign that is the supreme governing authority within the state. And that is strongly present in our constitutional discourse, in our constitutional doctrine, where judges and others understand that the referendum device is a mechanism through which the sovereignty of the people is expressed, not in the Rousseauvian sense, but in the Hobbesian sense. That the people is the supreme political authority within the state, and not simply the constituents' power on whose behalf power is exercised. So in other accounts, the people authorises the state and retreats from the picture, retreats from the processes of government. The Irish Constitution refers to both at the same time. The people is the constituent power, but it also is a supreme authority in the sense of having the final say on the content of the Constitution. Now, I think conceptually that's totally incoherent. It doesn't work. The idea of the people as a sovereign, as a supreme authority in the context of the referendum doesn't work, because the people can't act spontaneously of its own volition. Realistically, what the people have is at best a veto power over proposals that are controlled by intermediary institutions, formally the Oireachtas, but in reality the government, the executive power of the state. In reality, the people, if it's meaningful to refer to the people as a unitary entity, the people have an influence over constitutional content, but they don't have control, they don't have a determining control over constitutional content, and certainly the people as such can't constitute a sovereign, either in the Hobbesian sense or in the sense that the British Parliament is a sovereign, or in the sense that it enjoys sovereignty in British legal theory. So I simply don't accept that that there is any meaningful substantive difference between the tradition of parliamentary sovereignty in the UK and the concept of popular sovereignty in independent Ireland as a realistic or a useful or a meaningful description of how power is distributed in a state. Simply because the people is not a sovereign in the sense that the Parliament is sovereign, and is not sovereign in a sense that is recognisable in the history of political thought. It's probably better to see the people as an ad hoc legislative authority which has an influence or a role in the constitutional amendment process, but which isn't sovereign or exercising sovereignty in that strict sense. And I think that the use of language of sovereignty around the referendum process serves to obscure rather than to clarify what role, what influence, what power the people actually enjoys in that context. What about judicial review? Okay, so unlike other English-speaking countries that seceded from the UK and its traditions, its constitutional traditions, what was distinctive, as Laura Cahalan said yesterday, what was distinctive about the constitutional order of independent Ireland was its abandonment of the principle of parliamentary supremacy or parliamentary sovereignty, if you prefer, meaning, roughly speaking, that judges were authorised to invalidate primary legislation, parliamentary legislation, on constitutional grounds. Now, since then, other countries, such as Canada, have moved away, partially at least, from a principle of legislative supremacy and have adopted hybrid models, but this was endorsed, or this was embraced much earlier on in Ireland. And as Laura mentioned yesterday, and not only the 1937 Constitution, but in fact the 1922 Constitution as well, made provision for the invalidation of legislation by judges, even though that power wasn't really enthusiastically exercised until the 60s at least. Okay? And that made Ireland, certainly in the 20s and 30s, and even in the 60s, that made Ireland something of an outlier. Okay? That power of judicial review had been established in the US since the early 19th century, but it was still the exception rather than the norm in Western European democracies. And what transpired in Ireland was a constitution which proclaimed popular sovereignty as its overarching principle, but which empowered the judiciary to have the final say on the content of the law, effectively, or on the constitutionality of the law at least. And in most constitutional cultures, that is seen as a tension, it's seen as a contradiction. A lot of our terminology, a lot of our classifications are borrowed from American liberal thinking. And possibly the most irritating phrase or cliche that we use or that you hear reference to is the counter-majoritarian dilemma, the idea that judicial review exists to protect individuals and minorities from political majorities, which is probably not a useful or accurate description of how political power is exercised, the idea that a majority acts through legislation in a meaningful sense, or the idea that legislative power gives expression to something amorphous called the popular will or the majority will. In any event, we have partly adapted and used American-inspired terminologies around counter-majoritarian checks and balances. Sometimes we do understand judicial review as a counter-majoritarian mechanism, but that understanding is largely absent from judicial discourse itself. Judicial discourse never really portrays the power of judicial review as a check on the will of the people or the will of the majority, if they are the same thing. Rather, the idea or the doctrine is that since the Constitution itself is popularly enacted, is enacted through a popular process, that judges, when they strike down parliamentary statutes, when they strike down parliamentary legislation, are in fact effectuating and respecting the will of the people and enforcing the supremacy of the popular will over parliamentary politics. And that is the doctrine that Irish judges themselves have largely endorsed. The idea of counter-majoritarian checks and balances, or the idea of judicial review in that sense as a counter-majoritarian mechanism, is largely absent in the way judges describe their own powers. Okay? So in 1995, in the abortion information case, for example, the Chief Justice says that the Constitution, as the supreme law of the state, represents the will of the people, which, of course, is an oversimplification of the role and the influence that the people actually enjoys in the constitutional amendment process, and is a handy way, if you like, of legitimating and explaining judicial review as a democratic practice, in a sense that simply isn't available in other states where constitutional content doesn't have that obvious link, that easy link to popular legitimacy. American judges can't really describe or understand their role in that sense because the Constitution is a more ancient document that's more difficult to amend, and whose, in the context of federalism, whose authority isn't clearly derived from a unitary people in the same sense that might be plausible in the Irish context. So insofar as we talk about judicial review as a counter-majoritarian mechanism, that, of course, is an expression of American liberal thought. It may be present in academia to some extent, but it is completely absent, or more or less absent at least, in judicial discourse itself. So how much time do I have left, Brian? 2 minutes. Okay, so how should we then understand the relationship between judicial review and democracy? I don't think that the idea of popular sovereignty as an internal organizing principle has much value. As a realist, I don't think it describes or captures a distribution of power, or even that it provides an organizing principle within a state in any meaningful way. At best, it has symbolic or formal value. Now, I have argued that it is misplaced to understand judicial review in terms of a conflict between majoritarian democracy and individual rights. I think it's unrealistic and inaccurate to say that judges mediate between the will of a majority and the rights of vulnerable individuals and minorities, partly for historic reasons, because judges simply haven't exercised powers of judicial review in that way. Powers of judicial review have been exercised as much to entrench unequal distributions of power. They have been used as much to entrench privilege as they have to empower minorities and individuals, and that has been achieved with reference, of course, to classical individual liberties such as rights of freedom of contract, freedom of the right to private property, freedom of association, and freedom of religion. On the other hand, I think on the one hand, the idea that judicial review is legitimized by popular sovereignty is far-fetched and suffers from the same kind of abstract thinking that plagues much of our constitutional thought. Okay? It is fictitious for many obvious reasons, and it's counterproductive to imagine that when judges strike down legislation, that they are somehow giving effect to the will of the people, that the will of the people is expressed on the one hand in the text of the Constitution, and somehow then again through judicial interpretations of the Constitution in concrete cases. That is a fiction for obvious reasons, and it's an unhelpful way of understanding the legitimacy or the role of judges. On the other hand, I think it is equally problematic to suggest judicial review is undemocratic simply because it undermines an ephemeral notion of majority will, or that it keeps a check on the majority. It is much more fruitful, I think, to bring the discussion away from highly abstract notions of democratic will or constituent power, or indeed popular sovereignty itself. What we need to investigate and what we need to discuss is how the culture of judicial review and the culture of constitutional law has affected our democratic culture and our democratic discourse in concrete ways. How does it distribute power in society and the state? How has it framed public discourse? Who has it empowered? So we might make arguments, I know I'm going over time, we might make arguments about whether it has brought net benefits. It has brought benefits, of course, the practice of judicial review. Whether it has brought a net benefit overall, of course, is immensely controversial, whether the benefits outweigh the costs, but we haven't really properly investigated the costs of a constitutionalized political culture in democratic debate, in democratic discourse, and one of the under-investigated impacts of judicial review in our democracy is the way in which policy issues and legislative issues are often unhelpfully framed in constitutional terms, and how, if you like, political discourse is divested to an expert constitutional domain. How constitutional thought, how constitutional review, if you like, stifles democratic discourse in the legislative process itself, where constitutional law is invoked as a barrier to reform, where constitutional law shuts down legitimate and often progressive proposals at the legislative stage. As lawyers, I think, and as constitutional theorists, we haven't sufficiently investigated those distinctive costs, those concrete democratic costs of constitutional review in independent Ireland. I'm sorry for going over time. Thank you for your attention.